We're back. Dina Dahl, Michael Popok together again. Seems like an eternity ago, Dina, that you and I covered almost in real time the oral argument related to presidential immunity. We gave our commentary then about what we thought would happen based on the questions that were being asked by people like Gorsuch and Alito and even Roberts. And we thought there were a number of uh-oh moments that if that held forward and ended up in and baked into the majority opinion, that it would be a win in many ways for Donald Trump. And boy, were we right. And now we've got the actual opinion. You and I haven't had a chance to talk about it. And I couldn't think of anybody better to kind of bat this around and walk through some of the hypotheticals that are out there that are scaring the bejesus out of our audience. Like, now can a presidential candidate, a president of the United States named Donald Trump or otherwise, order a drone strike of his opponent? Can he sell pardons? Can other aspects of public corruption, can it be controlled or handled, administered through the criminal justice system? Yes or no? I just did an interview. It's going to go up over the weekend on the MeidasTouch network with Judge Michael J. Ludig, who we've had back now. I think this is my third or fourth interview with him. And he is so apoplectic. I've never seen Judge Ludig this way. He's so apoplectic as a lover, believer, and defender of the Constitution, a conservative, a real conservative, a Federalist Society member, former federal judge. He said it was an abomination, and it was obviously reversed, and this opinion was reversed engineered. They started with wanting to benefit a person named Donald J. Trump. They didn't care about the precedent that they were setting, and then they were backed in and reversed engineered without any intellectual honesty whatsoever in their analysis into this decision. And that's from Judge Ludig. And so my head is still spinning from that interview. And I said, I got to get Dina on here because you heard what I heard during the oral. Now you've seen the majority 6-3 decision written by none other than Chief Justice Roberts, who's been struggling to regain control of this court and make it the Roberts court. And maybe he's done it, but in a way that undermines democracy and our constitutional republic. I want to hear from you, and then you and I can do this thought experiment about, okay, what crimes that normal thinking people think should be crimes are no longer crimes if you happen to be the president of the United States.
Yeah, I mean, I remember us doing that live analysis, the post thing, and it was pretty clear that they were going to break it down into 3 parts, which they did. The core Article 2, that was going to have absolute immunity, the private that wasn't, and then this in between that was going to go to the lower court. The only sliver of hope I remember having was whether or not Justice Amy Coney Barrett and Justice Ketanji Brown Jackson were going to get together and maybe convince people to come on board, because they had, I thought, a unique way of trying to kind of handle this. Justice Amy Coney Barrett, you could see in her concurring opinion, was still trying to have a less extreme approach, but with it being concurring, it kind of almost doesn't matter, right? They had their 6-3. I think this opinion shows that Chief Justice Roberts has kind of lost control of his court a little bit to his extremists. We saw when he saved Obamacare that he was really trying to make sure that the court didn't take too much extreme positions. He lost on Dobbs too, and I think we see it again that he lost. And the fact is this opinion went farther than it needed to for this particular case, and then was a little bit too vague for this particular case. And then deciding that these Article 2 powers, which we mentioned, that and just as a brief overview, what are the Article 2 powers of the presidency? It has to do with the military, right? He's the commander in chief. It has to do with pardoning. That's an Article 2 specified power. Entering into treaties and nominating justices and other officers. Those are the core Article 2 powers that they were speaking of. Former President Trump's, when he was president at the time, these actions having to do actually with the DC January 6th don't really implicate, They don't implicate the treaty, the nomination, the pardoning, the military. So we usually see the Supreme Court trying to take the most narrow opinion that they can to decide the facts in front of them, because it allows for flexibility. They don't really want to make a decision based on the future, because a future case may not kind of happen the way they think. But in this particular situation, they didn't rein themselves in. They took a very broad approach. They decided on powers that weren't even part of this. To the other respect of some of those actions on January 6th were already basically decided to be private on a motion to dismiss. So they haven't fully gone through the facts. But, the police officers, the Capitol police officers, among others, are suing Trump, right, for civil immunity under that January 6th speech. And we found even the Trump-appointed D.C. appellate court judge say, that as a matter of law, they couldn't dismiss it because campaign money was being used for that speech. So the justices could have focused instead more on the unofficial private acts, which are going to be at issue in this January 6th, as well as these more vague outer perimeter actions. And just to really also just briefly talk about the outer perimeter thing and why that's important. There's the Article 2 powers, the unofficial contact, which is private, and then these outer perimeter. They took the standard that was in the Clinton v. Jones that said, if an official act has an outer perimeter, then the president has civil immunity. And they apply that outer perimeter to this presumption of immunity and a criminal. I thought that was kind of made more sense in a civil immunity than in a criminal immunity. It's a very broad understanding of official acts. And so that's one of the dangerous things about this opinion too, is that the use of this outer perimeter as possibly having a presumption of innocence, or actually having a presumption of innocence and maybe never being prosecuted. It's quite a big catch-all.
You're, without having seen the Ludig interview, you hit a number of his high points. No, I'm not kidding.
Okay.
which is great. I mean, he actually offline, he told us that Roberts has been struggling ever since Obamacare to kind of reaffirm his bona fides as a small C conservative. I don't think this has done him any justice, but sort of has given up on trying to fight the MAGA right wing, and has instead decided that, one way to regain footing have it be the Roberts court, as opposed to being the Alito court, which is what it was appearing to be starting with Dobbs, is to just join with them rather than fight them and make every opinion, give it to yourself and make yourself the Chief Justice. And having lost Dobbs and having, as you said, which I thought mattered to him, and Obamacare, he's just capitulated and decided this is going to be his chapters in history. But that's one. Secondly, I on the vagueness observation, I think that's a great one too, because what they've done to benefit a person named Donald Trump, which you're not supposed to do as the United States Supreme Court. You're supposed to be making constitutional precedent to be applied for all situations and into the future, not benefit one man and a candidate running for office, which is obvious what they did. They started with, we're going to give him absolute immunity, and we're going to issue this decision so late that he can't be prosecuted. And all the things that we're going to be sending back as window dressing back to Judge Chutkin. We're not going to give her any time, and we're going to hamstring her in returning it to her by saying, oh, by the way, the prosecutors can't talk about motive when they're looking at whether something's official conduct or not, and evidence is limited about whether the distinction between official and non-official conduct. And as you said about vagueness, we're going to talk about core powers, and we'll list a few of them, but we're not going to actually define them once and for all as to what are the Article 2 expressed core powers. Now, I made a list. My list is 7 long. I've seen lists that are 9 long. There's some unity among people about core powers. It's ambassadors and a foreign policy and conducting treaties and commander-in-chief and issuing pardons and appointing and removing executives and taking advice from the cabinet members, maybe. But then there's a bunch that some people agree are core and some people don't. So it's this vagueness about what is going to get absolute immunity and why in their talk about speaking out of both sides of their mouth, which they did frequently in the decision that pissed the shit out of me. But one of them was when they said, we're a reviewing court. We're not the trial court. This should go back, of course, for a better and further record to be developed by Judge Chutkan at the district court level. Oh, but while we're here, why don't we tell you about the one involving Jeff Clark and the Department of Justice and the weaponization of the Office of the Attorney General and the Department of Justice to try to cling to power? That's absolute immunity, and you don't even have to bother looking at that one. Why is that absolute immunity? I'm not sure that conversations with your Department of Justice in order to try to interfere with the Article 2 succession of power is automatically absolute immunity, but it is now. The other way they spoke out of both sides of their mouth, I want to get your opinion on this, of course, Dina, is when they completely minimize what happened, what the indictment alleges happened through Donald Trump in the indictment. They act like, well, there was just conversations with members of the Department of Justice about possible fraud. That's how they interpret the indictment. That's not the indictment. So by shrinking the indictment down so small you can drown it in a bathtub, right? Then you can say, it's like the MAGA people that make Jan 6th and the attack on our Capitol, where they try to set fire to the Capitol and assassinate elected officials, just a tour of the Capitol that went awry. It was just terrorism, right? It was terrorism. So you have that. And then you have things that you and I observed during the oral argument, which are obvious. They can't be debated, which is this is the first time in the history of the presidency in 250 years that a former president's ever been criminally indicted and prosecuted. And then during the oral argument, there was sort of this rejection of floodgates being opened. Well, how could there be floodgates open? It's the first time in 250 years. Yet in the decision by Roberts, he says, well, in the hands of a young prosecutor working for the next administration, and this interference or obstruction of government functions, we could have, a floodgates could be open of prosecutions of former presidents. How? Why? It's never happened. So that whole, once I saw how they were going to minimize the allegations of the indictment, coupled with how they were going to argue that we're saving democracy, even though we're totally imbalancing the delicate balance of the three co-equal branches of government by putting our fat thumb on the scale in favor of one branch, in this case, the executive branch, and elevating that branch above all others as to an imperial presidency akin to a king. I said, well, we're done. We are cooked. Tell me your thoughts on that, and then let's run some scenarios for our audience about killer, murderous presidents of the future.
Okay, so you're so right on so many things. Absolutely, they minimized it. The question should have been, if somebody's trying to stop the peaceful power presidency, which is what he's being charged with, does that have absolute immunity? This is what struck me about the in-between, the outer perimeter, which I already thought was broad, and then saying that has a presumption of immunity. It sounds a lot like qualified immunity. Essentially, that is what qualified immunity is. If a government actor is sued, they kind of have a presumption that what they're doing is within their powers, and you have to overcome that presumption. So it makes it a little bit harder to sue a government actor acting in their official capacity than a private person doing the same thing. But the reason why I think it's so dangerous in this particular thing is because you're applying this presumption in a criminal aspect rather than in a civil aspect, which I can think of no other situation where that is the case. And you already, and the reason why it's not necessary is, one, a civil lawsuit has a lower standard, right? You just have a preponderance of evidence versus this beyond a reasonable doubt. So you have a little bit more protection if you're a criminal defendant than if you're a civil defendant. And then the other thing is that you have a presumption of innocence when you are a criminal defendant. You don't have that as a civil defendant. So they added on an extra layer of making this more difficult. than you would in a civil suit. A civil suit, you don't have a presumption of innocence if you're a civil defendant. So you don't need that in a criminal case. And by doing that, by adding like a third layer of protection that's already above what's baked in when you're a criminal defendant, was what makes this so dangerous and so unnecessary. To your point about them being worried about there being floodgates, you could worry about floodgates with a civil lawsuit because you don't have the same kind of protections as a civil defendant. But a criminal defendant has so many protections baked in. We have so many constitutional protections as a criminal defendant. That in itself is a protection against the floodgates. And really, I remember Justice Sotomayor making that point in oral arguments, which is we shouldn't have to worry about that because there's so many layers in our criminal justice system that did it. So for them adding on top of the presumption of innocence, on top of this higher standard of proof, an extra layer of presumption to the president alone is something that's so different. We see police officers all the time, right, getting on trial for whether or not their actions of killing somebody is within their conduct or it's criminal. And at the end of the day, I don't see how they can say that a criminal action is by nature an official action. I think it's an oxymoron. You can't have it both ways. That's why a police officer has to be, it's a trial of fact to decide. And here, when they've added that extra layer of a presumption of immunity, they've taken that away, and they can make it that a criminal act is still an official act by adding that extra layer.
Yeah,
and I think that's what made it so dangerous.
And how is a prosecutor ever to overcome the presumption of an official act being immune by showing it won't unnecessarily interfere with executive power? And you can't talk about motive. Oh, and you can't put on certain categories of evidence about official conduct. So try the case with both your arms and one leg tied behind your back and a partial gag in your mouth. And let's see if it's almost like, hey, this is, let's see if they can pull this off, a high wire act without a net. I wonder if they could do it. I mean, it's almost like a morose challenge to see if we could do it. And the reality is, think about this part, Dina. You've thought about it, but Julia, I'm positing it as a way to segue into our thought experiment. In the hands of a unscrupulous, a person who has no scruples. Sorry, it's been a long day for me. An unscrupulous, unhinged person who has no proper character and no moral conviction, now being given the reduction or the elimination of guardrails around the presidency. In the hands of that kind of person, this is a to-do list. This is an owner's manual. This is an instructional manual. This isn't a series of limitations. This is, I can get away with almost everything. Now, in the hands of somebody like Joe Biden, you're like, okay, he's not going to order SEAL Team 6 to take out his political rival, because the people that are pulling the trigger on that are going to go to jail because they're not immune. There's a lot of other checks and balances, and he doesn't want to get impeached, convicted, and removed for high crimes and misdemeanors either. But to Donald Trump, who's got nothing to lose, he'll be 80-something years old. He'll be lame duck the moment he gets in. He could do all sorts of things. And people have to think about, this is the new landscape that is being created by this Supreme Court with permission and license to whoever occupies that office. That position just got a lot scarier in the wrong hands. So let me ask you, let's run through this. We've got absolute immunity for core presidential functions. We've got basically absolute immunity unless the prosecutor can overcome the hurdle of proving that the prosecution will not unnecessarily interfere with the executive branch, which kind of it's like an exception that eats itself. And then you've got, if you can prove after that anything is unofficial conduct, good luck. It's almost like they're saying in the decision, good luck.
Yeah.
That you can prosecute. Good luck. And you've already done your indictment, so you're stuck with the original indictment. Okay. Go for it. So killer drones commanded by the commander-in-chief named Donald Trump going after political rivals. Absolute immune?
Yes. I think based on this,
Right. Now, there is some language, Karen and I debated it yesterday. There is some language, although, again, it's like throwaway language. Judge Ludig said in my interview, it's like a first-year moot court brief in law school. And we all wrote those. It's so short on analysis and any kind of intellectual honesty and long on everything else. Now, buried in there, besides the one-line comment, well, no man's above the law. Really? With no citation to anything, by the way, is this comment about, well, if the president were to exceed his constitutional authority the way Truman did when he tried to take over steel mills in Youngstown case, that would be outside of his constitutional authority. So I guess one argument would be that they would argue that there's a way to be inside and outside of core duties, that just because you're inside the rubric of foreign affairs or commander-in-chief or giver and grantor of pardons doesn't mean everything you do in there gets absolute immunity and you can't exceed it, and it's for the courts to determine that. So call me a cockeyed optimist. Karen certainly did. But I still think that a district court and then even this crazy right-wing results-driven Supreme Court is going to say, no, we're not going to have a murderous president. That's that's the stuff of Hollywood and horror films. We're not going to allow that. But the fact that you and I even debate this as seasoned lawyers is crazy.
Well, and not only that, but to even get to the point of whether or not it's murderous, you have to have some fact finding, right? I mean, this is the problem, is any charge or allegation has to be decided. So can they even get to the point of fact finding? That's the problem. So let's say there is a drone attack that kills somebody and somebody alleges it was done, with intent, a murderous intent, and it wasn't for a legitimate security purpose. In order to reveal if that's true or not, you would need access to security information and witnesses and testimony to determine, because for all we know, there could have been a basis for that, right? But to get to that fact-finding point, they'd have to go in front of a judge and have that judge agree that this wasn't an Article 2 core function. I don't know if you can even pass that. That's the problem, I think, is because to get to that fact-finding stage, you'd have to pass the initial thing. And you can have a judge like Judge Cannon say, you know what, that was part of the military. We're not even going to get to the stage if this was legitimate or not legitimate. And then is that Supreme Court going to say that, as a matter of law, this is not a core and can be then go to the fact finding? Because they're saying that the lower courts go into this kind of determination only in the outer perimeters, not the core function. So I think that's the vagueness that we talked about. And that's the worry, is that they can't even get to the fact finding on those Article 2, because if it's a military thing, it's Article 2. And I see a lower court dismissing that outright as a matter of law, because they say we can't even overlook it. I mean, their holding is really clear. No act of Congress and courts cannot review. That's what they say. They cannot review an Article 2 function. So I don't see how they get past a motion to dismiss when it has to do with a military commander-in-chief decision.
And they've left it so vague that it'll tie itself up in knots for years while that person continues in office. Or avoids prosecution because of the passage of time. And that's exactly, these little ticking time bombs that they laid inside of there. The other devil's spawn that we'll touch on here at the end that's embedded within the opinion is a little throwaway footnote 1 that says, oh yeah, by the way, Judge Chutkan, you don't have enough on your plate. You're already going to have to hold a mini trial about whether any of the indictment survives this new divining line that we've established for you. And you're going to have to go carefully through all the evidence and all the indictment allegations to see. But while you're there, figure out whether 2 of the charges even survive our decision in the Fisher case about whether obstruction of an official proceeding is an appropriate crime to be charged against Donald Trump. With a reminder that we did say if it goes to the integrity of the process, it may still survive. Or as Ketanji Brown Jackson put it in her concurrence, and as even ended up in the majority opinion, credit Justice Sotomayor, the creation of false evidence undermines the integrity of a process to support a 1512C2 charge. And what is false evidence? I would argue is the fabrication of false Jan 6th, false certificates certifying the election, the electoral college result. And those fake certificates would be fake evidence, fake or false evidence under that ruling. So, but oh, by the way, and then the other devil's spawn is in the concurrence by Justice Thomas that we knew he was directing right at Aileen Cannon in saying that the special counsel is illegitimate. The special counsel is not properly appointed or confirmed or budgeted, and therefore there should be no prosecution. And that's another reason the indictment should be dismissed. Now, the majority didn't adopt that. It didn't even address it, which means it's not the majority opinion. But already, Trump has already filed a motion for supplemental briefing and supplemental authority, arguing Justice Thomas was right. What are we even doing? Dismiss the whole indictment. And it wouldn't matter if it was in the hands of like Judge Chutkin, but Aileen Cannon's already said a couple weeks ago, I'm really interested as to whether the special counsel should even be is a valid appointment by the Department of Justice or Congress or not.
Oh, exactly. The last thing she needs is any like support to go down a breadcrumbs down a different trail. So she will end up citing him for sure at some point. Whether or not it's an oral or written, she will definitely cite him. Supreme Court justice has now raised this as, a possible legitimate interest. We noticed in that oral argument, they all went on tangents, right? Gorsuch they were all talking about their own little pet projects and that oral argument that had zero to do with the case at issue with them. And it just goes to show, I hate to kind of impugn the integrity of the Supreme Court too much, because I do believe that the legal system is so important, and it's I don't like to bash on them unnecessarily, but this is really dangerous. These opinions that we saw and the way that we saw them discuss on oral arguments for Thomas and Gorsuch and Alito are they don't. For Thomas to have said that, even though it wasn't in front of it, was so irresponsible on his part, and he didn't care, and that's really disappointing as a lawyer.
Yeah, I mean the argument that we're going to see back on that, then we'll end our. You and I could go on forever. We're gonna do it. I got something to talk to you about after this. After this hot take.
Okay, good.
But the majority opinion saw Clarence Thomas's concurrence before and did not adopt any aspect of it. And there is a very good argument that I assume the special counsel will make which is it was up in front of them. They had the concurrence and they implicitly at least endorsed the validity of the special counsel's office, because they said, go through the indictment. They didn't say, and also determine footnote 2, also determine on the first instance whether special counsel is a special counsel or not, or just a guy named Jack Smith who's running around prosecuting people privately when he has no power. I mean, they didn't say that. So there's always that argument that they knew it and they rejected that. So why does Clarence Thomas, first of all, why is he even writing? He should have recused himself. It's just a thumb in the eye of America that he's even being heard from, let alone that he's sending a love letter directly to Aileen Cannon. It's just really disgusting. And I'm less inclined, as is Judge Ludick now, I used to be very respectful of the presidency.
Right.
And every occupant of it, regardless of party or stripe. And that went out the window when Donald J. Trump crapped all over the presidency, the White House, and his the requirements of being the leader of the free world. He had no respect for the office, neither did his wife. And so why would I have respect for him? I mean, that's where I ended up. Yeah.
No, he changed the presidency in a really scary way, because we have kids. You have your baby and I have kids, and our kids are growing up seeing the office completely different than when we saw. We may have disagreed. I mean, George Bush was, brought us into that war. That was horrible. Yeah. They weren't perfect, but it was never like this. And it is hard. Sometimes we get so in the weeds about this, but to step back and be like, this is where we're at, that the Supreme Court is even doing this. The damage he has caused the presidency, we can't even fathom it yet, I think.
It's imaginable. Dina Dahl, Michael Popok, back again with a duet on things that we like talking about, which is constitutional law and where we go next. I know our audience is hurting, is reeling from this. And we've tried since July 1 in hot takes and in podcasts and in direct videos to our audience to make them see that there's a way to thread the needle of this and keep our constitutional republic on solid footing. And it really starts with as our president said in his speech right after the immunity decision came out, I'm paraphrasing, if the Supreme Court is not going to do their job, then the American people are going to be left as the ultimate court of public opinion to vote about whether they want a criminal, immune or otherwise, to occupy the Oval Office or not. And there's no other way to put that choice. It's in those stark terms. And so, absolutely. Yeah. And now that I'm back from, well, not really back, but now that I'm doing more of these and you're back, can we make a commitment to each other, do more of these over the summer?
Oh my gosh, I love it. Let's do it.
Okay.
Yeah,
me too.
for sure.
So for Dina Dahl and Michael Popok, signing off on this particular hot take until our next one. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.